Good morning. I'm here today to talk about the way the public participates in Coastal Commission meetings and actions, including ex parte communications. And just by way of introduction, first of all, I'd like to say that the artwork you see on this slide was all submitted by kids around the state as part of our public education contest, and I don't see why they should be the only ones who get to use the fun stuff. So everyone can look at some of the great art the kids around the state do about the coast. But first, a couple of things about public participation. All of you commissioners, received information about these topics and the statutes that govern them when you were first appointed to the commission, along with literally stacks of information about other rules and commission procedures. For those of you who've been here a long time, we always think it's good to review this information from time to time. And for those of you who were appointed over the last year, now that you've had some time to get your coastal legs and figure out how all the different pieces of the commission fit together, and I know you've all figured that all out, it's a good time to make sure the information is understood. It's also beneficial for the public to review this information so that the public has a better understanding of how and why the rules operate. To begin with, I first want to introduce the idea of due process and public participation. It's important to understand that the vast majority of your actions at these hearings constitute quasi-judicial or quasi-adjudicative actions, which means that you are acting much like a court adjudicating a matter that comes before it. You are holding a hearing, listening to a presentation of facts, and applying the Coastal Act, LCP policies and ordinances, and regulations to come to a decision. Thus, the law is clear that the constitutional guarantee of due process, which includes basic fairness principles, applies to your hearings just as it does in a court of law. We're going to come back to due process periodically during this presentation as we discuss public participation and ex parte communications. Public participation in Coastal Commission meetings and decisions happen under two statutes: the Bagley-Keene Open Meeting Act, which applies to meetings of all state bodies such as boards and commissions, and the Coastal Act, which obviously only applies to you. Both of these statutes have rules and requirements and carry potential monetary penalties to the person who violates those. In many cases, violation of these statutes could result in the voiding or overturning of a Coastal Commission decision. Ensuring that decisions are arrived at under the correct rules and are thus safe from challenge, at least on process grounds, is one of the goals of your legal staff at these meetings. Public participation under the Coastal Act was guaranteed by the legislature, and there were various legislative findings. Back one. No, we're not going back. Can you go back a slide or two? Thank you. The legislature found and wrote into the Coastal Act that the public has a right to fully participate in decisions affecting coastal planning, conservation, and development, that achieving sound coastal conservation and development is dependent upon public understanding and support, and that the process should include the widest opportunity for public participation. Further, in the Coastal Act, now we can go forward. No, well, we're back too far again. Anyway, ensure adequate participation by all interested groups and the public at large. Advise the public as to effective ways of participating in Coastal Commission proceedings. And public participation enables the Commission to recommend to other agencies additional measures to assure more effective public participation in programs. So we seek to maximize public participation at our public meetings. One of the ways all state agencies ensure that the public can be knowledgeable about their processes and decisions is by following the Bagley-Keene Open Meeting Act. As it sounds, the Open Meeting Act was passed with the intent of having government decision-making bodies conduct their meeting in public and not behind closed doors. The law ensures that the public is given 10-day notice of the time and place of the meeting, and that the public has an opportunity to watch, observe, and participate in the process. I'm not going to go through all of the details of the statute, which would take a long time, but rather focus on a couple of major points. What is a meeting? This is one of the most basic questions, but it's a bit more complicated than it seems. The definition of the statute is found in the Bagley-Keene Act at 11122.5a, and states, as you can read on the slide, a meeting includes any congregation of a majority of the members of a state body at the same time and place to hear, discuss, or deliberate upon any item that is within the subject matter of the state body to which it pertains. So this can include items for voting or items for discussion. Excellent. And the definition then goes on to state, and this is where it can become more complicated, that a majority of the members of a state body shall not, outside of a meeting authorized by this chapter, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on an item or business that is within the subject matter of the body. This is the provision that bars what are known as serial meetings. And the point is, any time a meeting occurs, it must occur in a properly and publicly noticed meeting open to the public. And a meeting can still occur even if a majority of the commissioners are not present in one room or in one phone call. An example of a serial meeting would be a submajority or quorum of commissioners discussing an item within the commission's jurisdiction, and then one or more of the commissioners speaking to enough other commissioners to constitute a majority. A serial meeting can occur even without members of the commission realizing that they are participating in one. For example, if one of the members of the commission does not speak to any other members, but the second member does. The first member would have no knowledge that a serial meeting was then occurring, but particularly if some conclusion is reached amongst commissioners outside of the public eye, that would constitute a serial meeting. Intermediaries, too, could conduct serial meetings. People conducting ex partes or other meetings with you, raising the same topic with multiple commissioners and seeking to reach an agreement amongst commissioners can constitute a serial meeting. So a best practice would be not to discuss substantive commission business with other commissioners outside of a publicly noticed meeting. And in addition, when conducting ex parte communications, to gather information but not to reach conclusions. A subcommittee. From time to time, the Commission convenes subcommittees. Subcommittee meetings are not public meetings. They are, by definition, less than a majority of the commissioners. And technically, a subcommittee may be any number of commissioners that are less than a majority. But for reasons both legal and practical, this Commission has limited its subcommittees to 2 to 3 members. On a legal level, limiting the members on a subcommittee provides protections from inadvertently convening a serial meeting. For example, a majority of this body is 7 members. Should a subcommittee be convened that had 6 people, all it would take is one commissioner inadvertently discussing a topic with 1 non-subcommittee commissioners for a serial meeting to potentially have occurred. And from a practical perspective, larger subcommittees are just more difficult to schedule. Public notice and participation. Under Bagley-Keene, the Commission must give at least, one more. No. Yeah. We're out of order. Public notice and participation. Under Bagley-Keene, the Commission must give at least 10 days public notice of a Commission meeting, including the time, date, and location of the meeting, as well as a brief description of the items to be discussed or acted on at the meeting, including whether those items are for discussion or action. So sometimes an agendized item will bring up a different topic, and you may be interested in discussing that topic. But when this happens, we try and note that it must be agendized for a future meeting, and at that point, have the item on the Commission agenda with a brief description. In addition, while items may come off of an agenda within the 10-day period, they cannot be added once the meeting is within 10 days of the noticed agenda. Public participation. The Bagley-Keene Act ensures that the public may speak before or during each item on the agenda, as well as on matters not on the agenda, and submit written materials. As you have seen, the Commission strictly follows this mandate by having comment periods for each item, as well as a comment period for matters not on the agenda, and by collecting and distributing written or electronic materials. The Commission's process also embodies the Coastal Act mandate to provide for maximum public participation. The Commission may adopt reasonable and fair rules to govern these comment periods, such as limiting the time members of the public may speak for, so long as the rules apply equally to all viewpoints on a matter. And you will note that your chair and vice chair assign the same amount of public comment time to each member on a matter, to each member of the public on a matter. In addition, You also see this principle in play when the Commission completes the public testimony portion of the hearing and deliberates. And the reason the Commission doesn't allow one interested party or another to continue to testify at will during Commissioner deliberations is the right to ensure the due process of all the interested parties. The comments made by the public become part of the record on an item, and the Commissioners may use information presented during the public comment as part of its substantial evidence in making decisions. This, however, brings us to the one entitlement of the public to participation that is not open and occurring in public, ex parte communications. The direct Latin translation of ex parte is by or for one party. The phrase is used in law to refer to proceedings or communications that are brought by one person in the absence of another, which obviously does raise issues of fairness, and it's these sorts of fairness concerns that the Commission's rules are designed to address. The Commission owes a duty to the parties that come before it to proceed in a manner consistent with these principles of fairness and due process. And in addition, as I mentioned earlier, as a practical matter, if you fail to observe these principles, your decisions may be at risk of being overturned, or you may be at risk personally for penalties. For most of this Commission's history, it wasn't clear Commissioners could engage in ex parte communications, but at a minimum, such communications were highly suspect by courts, and courts have traditionally frowned on this sort of contact. On the basis of many California cases, as far back as 1974 for the Coastal Commission until at least 1988, the Attorney General's Office consistently advised Commissioners to discourage parties from attempting to provide them with information outside of the hearing, or to avoid them entirely, and if they did occur, to disclose them. And more recent judicial pronouncements, including a 2006 California Supreme Court case, suggest that ex parte communications still present due process issues. However, in the early 90s, the legislature specifically adopted ex parte rules for this Commission, which expressly permit ex parte communications, provided that all such communications are disclosed as required by the statute. Those disclosure, I think we can keep going. Those disclosure requirements are key for at least 3 different reasons, and these reasons also give you guidance about how much disclosure occurs. First, they're key to the fairness principles we've been discussing because they ensure that the parties know what you've heard so that there are no hidden facts influencing your decision. If someone disagrees with what you've been told, they have the opportunity to respond and present their own view of the facts. Second, having all the facts that form the basis of your decision on the record so that everyone knows what they are has an additional practical advantage as well. Once ex partes are disclosed, they cease to be ex partes and become part of the record and part of your substantial evidence. If your decisions are challenged, the standard of review requires that there be the substantial evidence in the record, and if evidence is left out, the Attorney General's Office is at a disadvantage in defending your decisions. And finally, disclosure is necessary to promote the openness principles in the Coastal Act findings, as these disclosures requirements guarantee that you make your decisions in a manner that ensures the general public is aware of your basis for your actions. And with these principles in mind, the rest of what we'll talk about will focus on the nuts and bolts of the rules that the legislature adopted for the Coastal Commission. The Coastal Act provides its own definition of the phrase ex parte communication. It applies to any oral or written communication if it occurs outside of the official meeting record with an interested person about the matter within the Commission's jurisdiction, so that includes meetings and phone calls as well as documents you receive, email messages, or any other type of communication. It also includes any individualized communications you receive during the hearing. For example, if you receive a call on your cell phone or an email message while you're at the hearing. It does not include communications to schedule an ex parte or procedural matter, or any procedural matter related to the hearing item. So if somebody emails you to ask, can we schedule an ex parte, that communication itself is not an ex parte. More definitions. The definition of an interested person. The definition applies to interested persons about matters within the Commission's jurisdiction. So knowing what matters are within the Commission's jurisdiction is important. You can see that this definition is very broad and really applies to almost every sort of application for a permit or plan or an amendment that comes before you. If an application has been submitted and you'll be making a quasi-judicial decision on that application, the matter is subject to your jurisdiction. As indicated by the underlined text at the end of this slide, the application has to have been submitted. So until there's one on file, communications about a future matter are technically not ex parte communications. But once the application is on file, even if the hearing hasn't been scheduled and may be months away, the matter counts. One thing you will notice is not included on this list are enforcement matters. And the AG's office has advised that commissioners are not, that it is not advised to engage in any ex parte communications concerning enforcement matters because of the heightened judicial nature of those proceedings. And additionally, the legislature did not call those out as being matters that ex parte are proper on. The statute also defines 3 categories of interested persons. These include, first, next slide. First, applicants and other participants in the proceeding, and secondly, people with a financial interest in the matter. Also, it includes agents and employees of each of these 2 groups. And finally, it includes people representing various interest groups, from neighborhood groups to environmental and civic groups to business groups, regardless of financial interest. Remember as well that these definitions establish the minimum requirements from what must be reported, so if you aren't sure, you may always err on the side of reporting communications with a person who appears to fit this concept, or you can check with us if you have any questions. Exclusions. The statute also excludes certain people from the definition of interested persons for ex parte communication purposes. And this slide shows a list of the types of communications that are specifically excluded. You don't need to worry about communications with your staff or communications about procedural issues. If an interested person contacts you to schedule an ex parte, that is not itself an ex parte. Many of you serve on other state or local bodies, and you can see the communications that you have in your official capacities on those boards, even if they are about matters that will come before this commission, are not ex parte communications. And finally, there are some exclusions for communications by non-voting commissioners. As I mentioned before, the legislator has made clear that ex parte communications are generally allowed, provided you comply with the disclosure requirements. However, they are never mandated. You are not required to take ex parte communications, and no one has a constitutional or statutory right to engage you outside of the official record. You may decline a request for an ex parte meeting, whether on principle or simply because you don't have the available time when it is requested. Someone may ask you for an ex parte communication 10 minutes before the hearing begins, and you simply just don't, or 4 people may ask you, and there would simply be no possible way to have those, even if you would be otherwise willing to do so, and there is no obligation to try and make that time. In addition, as indicated in the matters within the Commission's jurisdiction definition, the allowances for ex parte communications covers a wide range of Commission actions, but it does not list enforcement actions. Again, because enforcement proceedings are more like prosecutions, with your staff acting in the role as more like a prosecutor and the alleged violator more like a defendant, the Attorney General's Office has advised us that the heightened due process requirements for such hearings may make any ex parte communications inappropriate. Next, I'd like to review the disclosure requirements. As we've indicated above, when you engage in allowable ex parte communications, it's critical that you comply with the disclosure requirements. In order to comply with the statute, in order to protect the integrity of your decision and to provide a complete record of your decision, and even to protect yourselves from personal liability. First, disclosures must be on the record. If the communication occurs more than 7 days in advance of the hearing on the matter that's discussed in the ex parte communication, you have to complete the disclosure form and get it to staff before the meeting begins. This means you shouldn't wait until the item is on the agenda and then disclose it on the mic at the beginning of the hearing. It must be disclosed in writing ahead of time, and once that is done, there's no need to disclose it at the hearing. For example, if at this meeting an interested person approaches you and wants to have an ex parte on a matter for a future hearing, You obviously would not be able to disclose it on the mic at the next meeting because that next meeting is more than 7 days from now. So you would fill out the form and submit it now, and that form will then be attached to the staff report for the public to see and be able to respond to. Then at the next meeting, you can say your ex partes are on file. However, if you have other communications on that item within 7 days of that hearing, then you must disclose those communications on the mic at the hearing. Disclosures must identify who was involved, where and when it occurred, and a complete description of the communication. That last factor is obviously one that is subject to some discretion on your part to determine exactly what you need to say. Clearly, you're not expected to transcribe everything that was said in your conversations. However, you do need to bear in mind that one of the key purposes of the disclosure requirements, in addition to general transparency, is to allow interested parties to understand what you've learned that may be influencing your decision, so that if they have a different perspective, they can then respond during the public comment portion of the hearing. So if someone gives you a thorough explanation about why their project should be approved, and you simply say in your ex parte that you talked to someone about the project and they said you should approve it, that's not really complying with the purpose of the statute or with the disclosure requirement of the statute. There has to be enough in your report so that someone can understand what you were told and be able to respond to it if they want to. In addition, this assists your legal team in being able to defend your decisions. If there was information that you relied upon when you made that decision, you should include the substance of it in your disclosure so that we can include it in the substantial evidence in the record. One thing that is not part of a disclosure, however, is your own thought process or comments during an ex parte. Part of what you were doing up until the time you deliberate and make your decision is gathering information and not forming an opinion, but listening to all the information before you so that you can make a decision once all of that has been presented. So your own thought process along the way is incomplete and really is not a proper part of that disclosure. And in addition, you should be sure to send any written communications that you receive ex parte to staff so that staff has a copy and then may also include those in the written record. There's also an additional prohibition in the Coastal Act which basically says that if you do engage in ex parte communications and you don't disclose them, you can't participate in the decision or attempt to influence other commissioners or the decision. So that's a recusal requirement that's included in the statute. And finally, just a couple of closing points regarding noncompliance with the rules. Failure to comply with the disclosure requirements or the recusal requirement can expose you to potential civil fines and attorney's fees. As you can see, those fines can be up to $7,500 for any individual transgression, and the attorney's fees for whoever brings the complaint may also be awarded. Finally, in terms of protecting the integrity of your decisions, the statute does expressly provide for a party to seek a court order revoking your action if you violate the provisions on ex parte communications. So if there's found to be a violation, the decision that the entire commission reached may be revoked. And that concludes my presentation. And this is just a nice picture of a state park I think we'll be going to see shortly. Or drive by, anyway.
Thank you. Ms. Schmelter, if I could just start with a question. Whether or not there's any exemption for an ex parte with our appointing bodies. I've heard in the past that somehow they are exempt from ex parte, but I don't actually see anything in the presentation. So if you could just clarify that for us.
They are not listed as an interested person in the statute, and so they are not specifically called out. This would fall into the category of a commissioner may always report, but it is not, the appointing power is not specifically called out in the listed names of of interested persons.
Okay.
And unless they would actually be an interested party because they're the applicant or a financial have a
No,
financial
generally
interest.
they're once removed. Generally, the applicant or the representative have gone to the appointing body, who, in some cases in the past, have contacted commissioners. So you're saying that would not be covered?
That is not mandatorily covered.
Okay. Any other questions? Commissioner McClure?
Yes, on the serial meeting discussion in relationship to commissioners, I was under the belief that it's okay to talk about issues if we're not trying to find concurrence, if we're trying for information gathering.
If it is information gathering about an item before the commission, that really should be happening on the mic in front of the meeting. I think practically speaking, the way it might come up in a court case would be if there was a decision reached, but that distinction is not identified in the statute. And so discussing a matter amongst a quorum or a majority of commissioners.
No, I'm not
outside
talking about, I'm just talking like if I spoke to two, but then you
But then they
identified
spoke.
and then they spoke to two and then they spoke to two,
Yes.
that it could reach, but without seeking concurrence, but only seeking information.
It's still deliberating, and it's deliberating that would not, that members of the public would not see or understand the commission's deliberation process. So while, again, I think practically speaking, the likelihood would be that it would be challenged. There's a heightened level of risk of challenge when a conclusion is reached. The process of deliberating outside of the eye of the public by a majority of commissioners, even in a serial way, would be a serial meeting.
Okay, thank you.
Commissioner Mitchell?
Just clarification on that, but if commissioners are talking to each other, we are not putting new information into the record. I mean, we're not giving new information because we don't have any new information other than what was given to us through an ex parte, through the public presentation, et cetera. So I don't understand why that would then be suspect, because we're just talking to each other, but not putting in new information to change people's minds.
Well, I think that last part is the part that we can't really say in the abstract. There may not be new information, but obviously you often hear colleagues during the public portion of the meeting take information that was presented publicly and say, and this is why I think this is the most important thing, and this is why I would do X and such. So the fact that you're not introducing new information doesn't mean that as part of discussing it with your colleagues, that any individual commissioner wouldn't be adding their own thought process or analysis or reasons for looking towards one conclusion or another, even if they haven't quite made up their mind, and that may be influencing another commissioner. And if that commissioner then turns around and says, Commissioner X thinks this, and I found that very persuasive, there can be the same kind of deliberation that happens in a serial way.
Commissioner Zimmer?
I have a further question about the prohibition on ex partes and enforcement matters. And it came up for me this last week where we had an enforcement matter that was to be followed by a permit for the same property for the similar issues. And I was asked by both sides to meet, and when I realized that it was enforcement, I declined. Some commissioners did hold meetings on the related permit subsequent. So do you have any guidance on how much of a relationship there needs to be to make the subsequent permitting process suspect under the ex parte rules or dangerous based on that?
Again, it's going to be a very fact-specific inquiry and decision on the part of the commissioner, and ex partes are permitted on permit matters. However, when there's an enforcement matter that is related and the facts of the two items are largely the same, it would be my advice that it's very hard to separate out the enforcement matter from the permit matter, and as a matter of caution, avoiding the ex parte would be the most conservative route. However, commissioners do need to use their own discretion and avoid discussing the enforcement matter. But if a commissioner believes it can discuss solely the permit matter, then the commissioner may do so.
But the penalties all fall on us
Yes.
as individuals.
Yes.
And not on the person who might have inadvertently induced an inappropriate conversation.
That's
In
correct.
other words, the lobbyists, the agents. There's nothing in the statute that provides for penalty
That's
for
correct.
them. Okay. And then on the serial meeting question, it occurs to me to ask how that relates to the practice that we have, for example, on, I think in context of substantial issue on an appeal, we have a practice where 3 commissioners need to raise objections to avoid a presumption that substantial issue is found. If in reviewing a staff report, I have concerns about the propriety of voting for substantial issue, and I share that concern with 2 other commissioners to see if there's any support for having a discussion about it. Is that a problem in terms of a serial meeting question?
Well, I think it raises the same concern that 3 commissioners doesn't become a quorum.
Right.
Because of the nature of the matter. The statute is about a majority or a quorum. It does raise the same concern that any other serial meeting concern would be raised, that those other 2 commissioners may speak to more people, and you may not be aware of that, or even one or both of those other commissioners may not be aware of the subsequent conversations. I understand what you're saying
okay.
about the 3, but at the same time, I think the place for raising those concerns is to ask questions publicly or to seek clarification from staff about questions about the substantial issue.
Okay, thank you.
Anybody down here? Commissioner Mitchell.
So I have a question about site visits and the limit on only 2 commissioners, because I understand if there were a quorum of commissioners going on a site visit, but the fact that only 2 commissioners can go on a site visit, that doesn't make any sense to me.
Well, that has become, I think, a matter of practice about subcommittees, and there has been a general practice of only having 2 or 3 commissioners on a subcommittee, and that you have more than that. There's that you have basically a subcommittee without it being designated by the commission. So I think that has been the concern, but it is not a hard and fast rule.
Okay, because if it's not a designated subcommittee, I mean, I could see if the chair created a subcommittee, and then that subcommittee, did something together and took an action and made a recommendation. But if, 3 people want to share a car to go on a site visit because we're all going to have to drive to Long Beach or wherever, it seems to me like there isn't any reason that couldn't happen. 3 or 4 or 5, for that matter, 6.
I think that generally that could happen. The larger the group, again, the more likely you are to, especially if you're visiting a site that's a matter within the commission's jurisdiction, or that's likely to come before the commission, you're then running the risk of a serial meeting issue. But
we can take tours, and as long as we don't have a
quorum.
a quorum or a serial meeting. So.
Well,
Yes.
A follow-up question to that. So if an applicant or an environmental group seeks out contact with all 12 of us, which happens frequently, and they take us 2 by 2 on a boat tour, and they reach all of us at one point or another, how does that not become a serial meeting?
Again, this is, presumably this is an ex parte communication that each of the commissioners will disclose, and then they will become part of the record. But the commissioners, again, need to avoid discussing substantively the item with one another or reaching some sort of conclusion or consensus with the interested party who's reaching out to each of you. So that that person isn't saying, well, I've got an agreement, you know, I've taken everybody 2 by 2 to this site, and each of them separately agreed that the site meets this criteria or that criteria, and none of you would know that anyone else had done that. But
so if we don't know it's been, then do we have a problem or don't we? I mean,
I think this is where reaching conclusions becomes more important. If you're speaking with each other, there's the risk of people introducing analysis and argument that's not in front of the commission.
Right.
If it's more akin to an ex parte, that's a situation where you should be receiving information and then disclosing it, and that becomes part of the regular record, and that's again specifically allowed under your rules.
And I would just add, I think if you treat that kind of a site visit as fact-finding, you're out there to receive information, and then it's an ex parte and you disclose it, then that's okay. And that's valuable to visit a site.
What you have are 2 different statutes here that were not written with one another in mind. So we are meshing the 2 together. You have the Bagley-Keene Open Meeting Act, which is saying don't have serial meetings, and then you have the Coastal Act, which says you may engage in ex partes provided that you follow these rules. So we are overlapping the 2 to mesh them together in the best way we can. And I think Charles's suggestion that we treat that as fact-finding, and I think that's what I was trying to suggest in saying that you go and you take in the information, but you don't discuss it amongst yourselves and then reach some sort of conclusion is the way to approach that.
But the penalties for having a serial meeting flow to the commission as a whole, not to the individual commissioner. Is that right? Whereas the penalties for ex parte are ours as individuals.
I'm not sure that's correct.
I mean, if a
actually.
meeting is,
I believe they're each individual.
they're both so we're at risk as
Yes.
individuals in both cases.
I believe that's correct.
Okay.
Charles, in closing, I'm sorry to do this to you on the spot, but we talked about this a day or so ago, and you had a list of questions that you would advise commissioners to ask either the person asking for an ex parte or to ask themselves before they make the decision to have an ex parte. And if that's close to the front of your brain, would you run through that list of questions? Because I found it very helpful myself. I often don't know the answer to them unless I actually ask the person who wants an ex parte.
Sure, and I think these were embedded in Hope's presentation along the way. That the first thing to remember is that you're not obligated to have an ex parte, so you can manage your time, and if you don't want to do it, you don't have to. But if somebody asks you, I think the best way to manage the risk related to that potential communication is to ask the person who's contacting you, one, are you involved in any litigation? Is this a matter of litigation with the commission, yes or no? If they say yes, then best not to proceed. And then second, same question, is this a matter of enforcement in front of the commission? And if yes, best not to proceed. And if you just have that at the outset, ask whoever's contacting you those questions, and then that can help you decide whether to have the communication. And then if you're uncertain, you could contact us to confirm. There's so many things pending, it's difficult for you and us to have an active list of what you should and should not be talking about.
Right. If I may add one bit of clarification to Commissioner Zimmer's question, under Bagley-Keene and the serial meeting provision, The Act provides for misdemeanor penalties against individual members. If the member attends a meeting in violation of the Act with the intent to deprive the public of information to which he or she knows or has reason to know the public's entitled to receive. So there is an intent component to that. However, the penalty is individual. There is the ability for the prevailing party to recover attorney's fees, and that actually flows back to the commission, not the individual. But the misdemeanor penalty is attached individually.
Commissioner Norvell.
Yes, occasionally I get ex partes that come in writing. Pretty rare for me as a non-voting member because it doesn't really benefit them at all. But it comes in through an agency, and they can send it over to me in my department, often after the meeting. So it really doesn't have any opportunity to even influence me. So do I report that, or can I just trash can those, or how does it work?
After the action, if it's after the meeting and an action has been taken at the meeting, it wasn't continued, the item's no longer before the commission.
Okay. What if it came in a day before? I don't even have time to read it.
But if you haven't seen it, then it's not something you can disclose. However, if it's something in writing and you do receive it before the meeting, the easiest thing to do is to forward that to staff. If it's within 7 days, you still need to disclose on the mic that you received it. But once you disclose it to staff, staff will make it available on the web, the writing, and attach it to an addendum, so it will be public as well.